General Osteopathic Council and Wray.
Yes, Mr. Ozin.
My Lord, I appear...
Am I pronouncing you correctly, Ozin?
My Lord, you have. I generally answer to most variations on the theme, but I'm...
Still, one likes to get it right. Okay.
My Lord, I appear for the appellant, the General Osteopathic Council. My learned friend, Miss O'Rourke, Queen's Counsel, appears for the respondent, Mr. Wray, as indeed she did in the High Court in his successful appeal. As my lords will know, neither they nor I appeared in the original hearing before the Divisional Court or the GOSC's.
Am I being stupid? I'm just admitting that I haven't read the papers properly. The Divisional Court?
Yeah. Sorry, I'm misreading my own note.
Oh, right.
The committee
yes.
with which we are concerned
Yes.
of the GOSC.
Yes.
I do apologise. And as your lordships know, this is an appeal by the GOSC against the decision on the 15th of December of last year of Mrs. Justice Collins Rice
Yes.
in the Administrative Court, quashing the decision of the GOSC's Professional Conduct Committee of the 30th of July of last year.
Yes.
And the decision of the High Court related to Mr. Wray's statutory appeal against the decision of the PCC, if I may call it that. It found that his conduct, that is to say the PCC, amounted to unacceptable professional conduct, and it imposed the lowest possible sanction of an admonishment. As the court will know, permission was granted by my Lord Justice Stuart-Smith on the 29th of March of this year on terms that were unrestricted as to the grounds, but included reasons that required careful reflection on the part of the regulator. I don't know if the court is familiar with the terms of that permission decision.
We are. I don't think you need to take us to it unless there's some particular point you want to make. If you're just getting going on substance, can I just mention a couple of small things just to be clear? The council slip suggests you have a junior, Mr. Fawkes, who appeared below, if I'm pronouncing him correctly, but unless he's hiding behind you, you haven't.
I believe that he is attending by way of the remote link, as it were.
But he's not appearing as counsel.
He's not appearing.
No, that's right. It's not a problem. I just, we have, when we write our judgments, to say who appeared. And
Yes.
The council slip is printed off the database and can sometimes be misleading. Right. That was that. The second thing was, can I just say we were not helped by getting the authorities bundles as late.
Yes.
I had no explanation of why that was. When they did arrive, they were very substandard.
Yes.
No tabs, a break in the middle of an authority between bundles, shoddy photocopying. I don't particularly want to have a court of inquiry about why that happened, but can that note please be taken of that? Because it makes a real difference to our reading, especially in a case like this where there's stuff we want to look at beforehand, to get it only the day before, effectively.
My Lord, yes. I do have a note to extend my apologies on behalf of the appellant. There is an explanation, which is a combination of supervening personal misfortunes, which resulted in those who were responsible for putting together the bundle suffering a close family bereavement.
Well, we don't need to know the details. I'm sure there is a reason, but perhaps the only thing I will say is that it is common, though I think not universal, for the authorities' bundles to be done within chambers.
Yes.
Chambers vary. I'm sure yours are excellent, and the explanation may just be a particular thing that was wrong. But I'm not always sure that clerks and librarians people are as well versed in what this court requires as the equivalent bodies in firms of solicitors. So I think that's just, whether that's a relevant observation for this particular case, I don't know. Anyway, I've said all I need to say. Now we can get on with substance without being interrupted by housekeeping.
Thank you very much. My Lord, I alluded to the terms upon which permission was granted, and in broad terms, as the court knows, it was granted with a view to considering matters of general importance. The GOSC has taken on board the reasons given at that time and has sought to restrict the matters to be argued before your lordships to the issues of widest regulatory importance, both to it and to the regulatory and disciplinary sector more generally. And as such, it focuses in its skeleton argument of the 10th of May of this year on the first two grounds that were originally raised, rather than the more fact-specific grounds contained in the residue of the original 7 grounds. Those grounds are, that is to say, the two that we focus on.
Well, when you say fine, I'm all for focus, but we do need to know formally whether you are abandoning certain grounds or merely downplaying them.
The position that we adopted in our written submissions was that we took the view that the other grounds were, as it were, embraced within the ambit of the first two, and they were really fact-specific manifestations of the two main complaints. But for practical purposes, I'm going to address the court on grounds 1 and 2, and we do not invite you to make specific rulings in relation to the residue as I've described it.
Well, let's see how we go on that. I'm not sure that's going to be quite as easy to translate into a decision as it may sound, but we'll hear your submissions and decide where we are.
Yes. Well, it may be that I can sharpen the edges of our position after taking instructions in due course. So as the court knows, the first ground is that we respectfully submit that the learned High Court judge wrongly went behind the adjudication of a criminal court and dealt with a registrant in a manner that was inconsistent with his guilty plea before a criminal court, and in so doing wrongly interpreted Section 14 of the Powers of Criminal Court Sentencing Act 2000 to the effect that it requires a statutory regulator to relitigate the factual basis of a guilty plea before a criminal court. And as the court knows, the effect of that provision is at the heart of this appeal.
I can't quite see why it is, because this wasn't a 21C case, it's a 21A case. But anyway,
Could we establish some common language, just so I don't get confused or more confused than I am at the moment? In the rules, the description that's applied to 21A and 21C, or 20A and, yes, 21A and 20C, is cases relating to conduct and cases relating to conviction. Could we adopt that as a nomenclature or some way?
Certainly.
The second thing, which just demonstrates how rusty I am, the critical document, both in this profession and elsewhere, is the complaint, which in this jurisdiction, under the rules, is formulated and sent to the osteopath, and then that's what he has to deal with. Here, it's common ground that this is a case relating to conduct. It's treated as a case relating to conduct. But there were 2 paragraphs to the complaint, as I understand it.
Yes.
What I can't remember is what you, who do this every day of the week, as it were, call the paragraphs. Are they heads or are they paragraphs of the complaint? Well, how do you describe 1 and 2? Because we're going to refer to them quite a lot.
Yes, it varies from regulator to regulator, but ordinarily, certainly in my experience, they're simply referred to as allegations, or sometimes
allegation 1, allegation 2.
Yes.
Can we adopt that today?
I will.
Subject to changing.
Would your lordship allow me to turn my
Yes,
back,
of course.
because there are people in the court who know more about a particular practices in this regulator. Yes. I'm instructed that in relation to the practices before the GOSC, the practice is to call them particulars.
Particulars, okay.
Yes.
So there's 1 complaint which is sent to the osteopath, and in this case it had 2 particulars.
Yes.
Thank you.
I'm grateful.
Well, you say that's what they're called. If so, that's not appropriate, because a particular is a particular of something of something. But what is the something of which they are a particular?
Yes, they are particulars of the allegation.
But you've said, but what is the allegation? I suppose you could say the allegation is unprofessional conduct, but that's not much of an allegation. You've got to allege something particular. And it doesn't matter, as long as we understand, but I, speaking for myself, I rather prefer allegation 1 and allegation 2. However, we're not going to go to the stake about this, as long as we understand one another. Yep.
As my lords know, the second ground that we seek to advance is that the learned High Court judge wrongly found that it was not permissible for a regulatory committee to hear contextual factual evidence after announcing its finding of fact, and wrongly found the procedural rules of the appellant required them to consider facts and UPC, if I can use that abbreviation, together, adopting the Lord's terminology, a conduct case. And we say that that was unduly and unnecessarily restrictive and contrary to established good practice across the regulatory sector. Subject to your lordship's view, I thought that it would be helpful to begin by going to the relevant provisions in question. If my lords have a copy of my first, not my supplemental, but my first skeleton argument, we set out, this is in the core bundle, tab 13, page 101.
We don't have any tabs in our core bundle, so if you just give us pages.
Certainly. Page 101 onwards is the beginning of the document, and we set out at page 107 Section 14 of the 2000 Act, and the parts that we suggest are most material. The Lords will see. If you wish to go to the...
I'm sorry, well, I didn't mean to make everyone else do it, but I prefer always to look at it in the...
Certainly. If you go,
Behind tab, my clerk has put in tab, so it's tab 8, page 75 in the authorities.
Indeed. So, authorities bundle, page 75. Section 14 bears the title Effect of Discharge. Subsection 1 reads, subject to subsection 2 below, a conviction of an offence for which an order is made under section 12 above, discharging the offender absolutely or conditionally, shall be deemed not to be a conviction for any purpose other than the purposes of the proceedings in which the order is made, and of any subsequent proceedings which may be taken against the offender under section 13 above. And I don't think in this bundle we've got section 13 immediately preceding, but as the court will know, that relates to the commission of further offences, which justifies the court looking again at the initial matter. And then I'm going to skip, if I may, subsection 2, move on to subsection 3. Without prejudice to subsections 1 and 2 above, the conviction of an offender who is discharged absolutely or conditionally under section 12 above shall in any event be disregarded for the purposes of any enactment or instrument which A, imposes any disqualification or disability upon convicted persons, or B, authorises or requires the imposition of any such disqualification or disability. And the court will note that at subsection 5 some of the terms are defined. I don't, for my part, think that it's helpful to read any of the other parts.
Can I just ask you, Mr. Rosen, it says at the top that it's been superseded and was in force until November 2020.
Yes.
It's been reenacted in a subsequent act.
It has.
I think you've given the particulars in your skeleton, haven't you?
Yes. If my Lord looks at our skeleton argument at paragraph 18, it has been repealed and reenacted in substantially the same form
Yes.
in section 82 of the Sentencing Act 2020 as part of the new sentencing code created by that enactment. And that appears at page 78 in your bundle, in the authorities bundle. And I don't propose to read it out, but
I think that's enough on that. Yep.
Yep. May I invite my lords to go to the Osteopaths Act. The full version is contained in the supplemental bundle. There were tabs, but I dare say it's going to be idle to refer to them. And I invite the court to turn to page 121 is the beginning of the Act.
Sorry, page.
In the supplementary bundle.
I've got the supplemental bundle. Yes, I see page 121.
Page 121.
sorry, I should have wrote this off my chest as well, that the paging of the supplementary bundle makes no sense, but it does work in the latter part of the bundle.
I noticed myself, I'm afraid, that there are some parts of the bundle where the pagination disappears altogether.
Yes, well, another lesson for someone to learn. But let's, we've got 121, so we've got the Act. Yes, where do you want us to go?
Could I invite you to go straight away to section 20 at page 147?
Yep.
And we'll also see section 20 sets out the different bases for bringing allegations, and the court will note the word allegation in section 20 subsection 1. And the court will see professional conduct and fitness to practice is the title. Subsection 1, this section applies where any allegation is made against a registered osteopath to the effect that A, he has been guilty of conduct which falls short of the standard required of a registered osteopath. And I pause there. If the court jumps ahead and looks at subsection 2, you will see that in this Act, conduct which falls short of the standard required of a registered osteopath is referred to as, quote, unacceptable professional conduct, or UPC, to use the abbreviation that I've been using. And if one goes back to subsection 1b, he has been guilty of professional incompetence. C, he has been convicted at any time in the United Kingdom of a criminal offence. Or D, his ability to practice as an osteopath is seriously impaired because of his physical or mental condition. And so the court will note that one has a fairly standard list in the enactment of bases upon which disciplinary charges can be brought against registered persons in professions. The rules develop the different categories and the way in which proceedings can be brought. Could I invite the court to go within the same bundle, bottom centre, page 192. The court will see here the rules in question, which are the General Osteopathic Council, Professional Conduct Committee, Procedure Rules Order of Council 2000. And then the relevant parts begin I think most helpfully at page 198. Court will see this is part 3, conduct of the hearing.
Before we get there, could I just mention? I think, speaking in terms of myself, I would like to see the letter which constituted the complaint.
Yes.
If that could be provided.
Will,
Not now.
yes, I will ensure that.
Not even necessarily during today, but
yes. Yes. And I think perhaps touching upon the question that my Lord asked a moment ago, it may be helpful to go back to page 195, where the court will see that part 2 is entitled Initial Consideration, and above Rule 7, perhaps I should just preface that by noting that there is a title, Action Following Referral, so there is a referral process which is followed at Rule 7 by the notice to be given to the osteopath And one notes, on referral of the case, the committee shall serve on the osteopath concerned a copy of the complaint that has been formulated, any document or statement on which the committee will be asked to rely, and a copy of these rules. And then it gives various matters that need to be notified to the registrant in preparation of any potential hearing.
But it's right, isn't it, that that document, the complaint, sets out the allegation which the osteopath has to meet. So it serves the same purpose as a summons in the summary courts or an indictment in the Crown Court, in that it defines the complaint.
Yes.
It is the complaint which the osteopath has to meet.
It gives the osteopath early notice of the general nature of the complaint.
Well, it does more than that.
Yeah,
If
it
you
does
look
more
at
than
Rule
that.
4,
Yes.
the solicitor, which is a defined term, is instructed to formulate a written statement setting out the allegation. So,
Yes.
echoing what my lord said, it's the equivalent to the indictment.
Yes.
It's the formal statement of the charge that the osteopath
Yes.
is to meet.
I made a slight reservation because there are occasions when reformulation is adopted, certainly by certain regulators. I don't think it applies in this case, so it's a matter of academic.
But then that becomes
Yes.
the defining
And
document.
that becomes the defining
Yes.
instrument.
But in the same way, you can amend an indictment in accordance
Yes.
with the indictment rules.
Yes. I think the division is perhaps more clearly indicated in the rules relating to General Medical Council.
Well, we needn't get involved in that.
Yes.
In any event, it's right, is it not? We don't actually have that document in the bundle.
I don't think we do, no.
No, well, that's what my lord has asked
Yes.
to be provided.
We
And
will.
actually, I think my lord very courteously said it doesn't even have to be during the hearing. I think, frankly, the sooner the better. So if we
Yes.
can get it at the short adjournment, if not before, that'd be helpful.
I invited my lord to go to page 198 at the bottom. Part 3 is conduct of the hearing. And tying in with the point that has been under discussion, if one looks at Rule 22, the hearing shall open with the registrar or the person appointed to act for him reading the complaint against the osteopath. Then Rule 23(1) at the bottom of the page. At this point, the osteopath or his representative may submit any objection on grounds of law to any part of the complaint, and the solicitor may be invited to reply to any such submission on behalf of the counsel. I draw the court's attention, invite the court to look at that provision because it reflects a significant part of the factual matrix, which is that nobody took any objection to the fact that in this instance the complaint, the allegation, consisted of a recitation of what had happened to the respondent in the criminal proceedings. And indeed, as I understand it, the gravamen of my learned friend's response is that there is no objection to doing that, although I think it is in the learned friend's skeleton argument for the purposes of these appeal proceedings. Perhaps the point is reserved. Her point, as I understand it, is that it counted as nothing on the facts and as a result of the operation of the sentencing provision, section 14 of the PCCA. Then could I invite the court to go over the page. The court might note Rule 24, again picking up on my lord's point. if at any stage of the hearing it appears to the committee that the complaint should be amended, the committee may, after hearing the parties and seeking advice from the legal assessor, make such amendments to the complaint as may seem necessary or desirable. Rule 25 gives the committee the option of sending the matter to the health committee, and then pertinent to this appeal is the division between conviction cases on the one hand and, to use the Lord Justice Stuart-Smith's terminology, conduct cases on the other. So Rule 26 deals with conviction cases. Rule 27 rolls together conduct and incompetence cases.
Yes, because health cases have gone off to the health committee.
Yes. And essentially, the court will see that there are three fairly conventional stages which apply in both contexts. So dealing with Rule 26, first of all, Stage 1 comprises proof of the conviction, comprising in its turn proof by certificate, that's subsection 1, and determination where it is raised of what I might describe by way of summary as a not me issue, where the registrant says, well, the certificate may be all right, but it's not me. They need to determine that, and the Lords will see that is at letters E to G in Rule 26. And going on, if one looks at subsection 2, they must go on to determine what is proved by virtue of admissions.
Which conviction? Which conviction or convictions are proved?
Indeed, yes.
Full stop. It's only convictions that's referred to.
Yes, the distinction made in Part 2 is that obviously they don't need to make a determination in relation to those that have been admitted because those have already been announced as being proved at 26(1)(d). So it wraps all of the conviction proof issues up. So there are two ways in which they can be proved. They can be admitted, at which point 26(1)(d), the chairman will announce that the conviction has been proved, or if there is a not me issue to be determined, it must be determined, at which point, at that point, there is a full determination following the raising of that issue where it is raised.
So do you describe paragraphs 1 and 2 as stage 1? So stage 1 comes to an end when the conclusion or the committee announce which convictions are in play.
Yes. Yes.
Yes.
Stage 2 then begins at sub-rule 3, which is the evaluative stage, comprising or involving the assessment of context, and it can include further evidence of the circumstances of the conviction, antecedents, mitigation and further evidence, and also a distinct stage.
I think you've misspoken. I'm very sorry to interrupt you. I think you've misspoken. It can include circumstances leading up to the conviction.
Yes.
It cannot include, as it were, the facts of the conviction itself.
Yes.
Is that, do you accept that?
It may be helpful to look at the actual.
So if you look at Rule 3,
wording 3, where the committee have found that a conviction has been proved or a conviction has been admitted, the chairman shall A, invite the solicitor to address the committee and to adduce any further evidence as to the circumstances leading up to the conviction. That's what the rule
Well, that
says.
must mean, mustn't it? I'm not sure I'm agreeing with my lord or respectfully disagreeing with him. That must mean the circumstances of the offence. Because you may get a conviction which simply says was convicted of
Yes.
assault. And this is presumably so that there can be evidence of who was assaulted, using what, in what circumstances.
Yes. It is the gateway through which documentary evidence pertaining to the circumstances of the criminal offence and the conviction gets in before the committee. And it is customary before most tribunals to have material of that kind where it is thought to be helpful or appropriate.
So it's not. Sorry, I was going to say it's not quite as clear as that, because if you look at 26(1)(a), at stage 1, the solicitor is requested to adduce evidence of any conviction and its circumstances.
Yes.
So the proof of the conviction is done by producing a certificate, which will be a fairly bald statement.
Yes.
That an individual was convicted of an offence on a particular date at a particular court. But that looks as if at stage 1, the prosecution, as it were, can adduce evidence of the circumstances of the offence.
Yes.
And then at stage 2, 26(3)(a), the solicitor can adduce any further evidence as to the circumstances leading up to a conviction. But
I don't, with respect, disagree with that analysis. It may be helpful.
On the face of it, it doesn't seem to make much sense. Well, my lord, you're about to explain why it does make sense.
okay, well, if one applies it to the facts of this case,
Yeah.
and this is not in any sense even a provisional view, you could say that the circumstances of the conviction itself are getting out of the car with the softball bat without a reasonable excuse. And the circumstances leading up to the conviction are daughter coming home, what she said, phone calls, what reason set out, and so on and so forth. I mean, that is a possible meaning. I don't know whether it's not, to my mind, clear on the face of the rules that there's some clear demarcation like this, but that could be what it means.
Yeah.
The logic would seem to be, and this is how you were explaining it before, which made perfect sense, that in a conviction case, all the first stage is concerned with is that there was a conviction.
Yes.
So all you do is you produce a certificate of conviction, and if there's a dispute, you show it relates to the person in front of you. That's all you do. But as my Lord Justice Nugee points out, what then is meant by 26(1)(a) and its circumstances? At the moment, although one could obviously distinguish between different sorts of circumstances, those, as it were, most which actually constituted the offending and those leading up to it, I'm not sure why you would need to make that distinction. Shouldn't everything, like all those circumstances, appear at the second stage?
Yes.
It says what it says, but I'm just trying to understand the thinking behind it.
Well, as
If you can't suggest any, it's no fault of yours.
Well,
it may just be this isn't very well drafted.
as my Lord articulates it, and as my Lord Justice Stuart-Smith articulates it, I suppose the question is the words "as to the circumstances leading up to the conviction" are limiting words, or simply another way of describing exactly the same thing as at subsection 1A, if I can call it that. That would be an interpretation. My understanding, and I know I may need to turn behind me to check the litmus test of what I'm saying in a moment, is that, broadly speaking, part 3 of the rule is regarded as an opportunity to put more stuff in, if I can put it as broadly as that.
Can I suggest, I mean, obviously I have no experience of how it is operated in practice, but it may be what the drafter of the rules had in mind, is that at stage 1, the solicitor produces the certificate of conviction, which, as I say, will be a fairly bald recital of the offence of which had been committed, and may, just to set the scene, and say to the committee, the registrant was convicted, as you'll see from the certificate, and it related to him having with him a softball bat in a public place,
Yes.
and so on. Not at that stage, because the committee is being asked to find anything or decide anything about the circumstances, but just to give them a bit of context. All they are asked to decide at stage 1 is, has the conviction been proved or admitted? And if there's a dispute as to whether it is this osteopath who was convicted, whether it was indeed him.
I am confident that your lordship's description as a matter of practice accurately reflects what happens in most regulatory tribunals, not just this regulator, but in most regulatory tribunals. There's a bit of scene setting at the time that the certificate goes in, and then where the rules allow for it, there is a further exploratory stage at which more material is provided.
But my lord's suggestion, what 26(1)A involves is the solicitor requesting evidence of any conviction and of its circumstances.
Yeah.
So to say, here's the certificate of conviction, and it says he assaulted X on such and such a day, at such and such a place, if the intention is that he'd be able to put some flesh on those bones, what is the evidence? Probably it would only be written evidence, but that doesn't quite, the sort of just, this is what it's about, which is obvious common sense, and nobody, I'm sure, would think was in the least bit objectionable. That's not really about evidence, is it? That's just laying out a bit of background. The evidence would be, and here's a statement, or a I don't know.
Can I?
Well, we're exploring.
Yes.
And,
Sorry, while we're exploring, can I throw another thing into the mix, which I'm sure you'd come to in course. But you have this bifurcation between conduct and conviction cases, and we're looking at conviction. The two routes come together again at 35.
They do.
And 35 says, in any case where the committee has found a conviction proved or has made a finding of unacceptable professional conduct or professional incompetence, and has heard any plea in mitigation.
Yes.
It is a quirk of the rules, as it seems to me, that there is specific provision for a plea in mitigation in a conduct case in Rule 33, but there is no equivalent in relation to a conviction case. And it is, the nearest one gets to it is 26.3, where other material can be put in.
Well, 26.3b, my lord.
3b. Well, the 3b and 3b, but it's in the context of the additional information of 3a.
Yes.
So, presumably, and you've also got 4, which is simply a relevance question.
Yes.
But mitigation has got to be found somewhere within 3b and 4, hasn't it?
Well, I would respectfully differ, if I may, as to the interpretation of section 26.3. relates to two different things that can happen. One is further evidence by the solicitor, and the other is an invitation to address the committee by way of mitigation and to adduce any further such evidence. So I don't think it is, with respect, dependent upon the solicitor going for the invitation at A, because the invitation at B still has to be given to the osteopath.
Is such evidence in B, the word such, referring to further evidence as to circumstances leading to the conviction and as to the character and previous history of the osteopath? And if not, what is it? But I think it makes sense. The solicitor says what he wants to say about the circumstance leading up to and the character and previous history, and the osteopath can then respond to that, putting in what he wants to about character and previous history, and if need be, about circumstances.
It does. My lord is plainly right. Such evidence relates to the phrase further evidence as to the circumstances leading up to the conviction and as to the character and previous history of the osteopath. It must
coming back to your...
to A, but I just pause because I'm conscious I might have cut my lord off.
No, I was cutting you off, so I'll let you finish.
I'm grateful. But in my respectful submission, as a matter of construction, the osteopath gets that invitation come what may. There are two invitations. Obviously, in construing what the invitation is, one needs to look back to A, but it's not contingent upon the invitation being given to the solicitor.
Can I summarise where we are? So I think there's a risk that we're making a meal of what ought to be extremely straightforward.
Yes.
In a conviction case, stage one is the proof of the conviction and, if relevant, that it applies to the osteopath. Stage two is the opportunity for evidence, ignore the word further for the moment, evidence and submissions about the circumstances of the offence and about mitigating circumstances and previous character, all the things that will be relevant to effectively sentencing.
Yes.
And that's perfectly common sense, and anyone would understand it, and it's very much like what happens in a criminal court. The only oddity, and it is an oddity which I don't think really needs to detain us, is what is meant by the opportunity for the solicitor to produce evidence at the first stage, not only of the conviction, which means producing a bit of paper, but of its circumstances.
Yes.
That is an oddity, but it's not one that's likely to cause any problem or injustice, is it? Because if that evidence is disputed, it'll be disputed at the second stage.
Yes.
Am I being too broad brush about this?
No, I respectfully agree entirely with your lordship's approach. The reality,
if you were able to explain, oh no, there is a particular reason for the 26(1)A evidence of the circumstances, be useful to know. But I think at the moment we're all slightly puzzled by it.
Yes.
Although we can make up a way of distinguishing it between what appears at the second stage and the first. But it doesn't really matter, does it?
It doesn't really matter, and one has to bear in mind that subject to training and guidance, each committee that sits must make what it will of the rules, assisted by a legal assessor.
Yeah.
And so practices do, in all regulators, differ slightly. But the general picture is you put the certificate in, perhaps give a little bit of context, as the Lord Justice Nugee suggested, and then you move to further evidence by either party and mitigation on the part of the osteopath.
Yeah. I mean, I'm just concerned, and I think it's extremely helpful, particularly given the overall grounds on which permission was granted, for us to understand this, but we are being very laborious about it. This isn't on any view actually a case under 26, no. So I think we do need to move on.
I respectfully agree. May I just make one last
yes,
point?
You said there were three stages. You got your first,
yes.
Which we looked at the second, which you call the evaluative stage.
Yes.
And the third is?
The third is go straight to sanction. If my Lord looks at sub-rule 5 over the page, the committee shall then proceed in accordance with rules 35 to 39. which is the sanction stage, one shouldn't perhaps forget subsection 4, which expressly permits the osteopath to make representations as to the relevance, if any, of the conviction to the question of fitness of the osteopath to practice osteopathy, which is a distinct stage that does appear in the rules relating to quite a number of regulators, but not all of them. And I think, as I've submitted somewhere in the course of my skeleton argument, it merely puts in express form what any regulator would have to do in any event, because it's not enough to prove the conviction.
Well, yes, that's true, but a conviction may be relevant in two ways, may it not? One, it may show they're not fit to practice,
Yes.
but two, it may show that, I mean, suppose you had someone who was guilty. Well, it's perhaps difficult to think of let's say a serious taps fiddle. You could argue that's not relevant to your fitness to protect. You could make some argument about, oh, well, honesty is important and so on. But broadly speaking, the reason why such a person deserves a sanction and may be struck off is it's not appropriate for osteopaths to have, for the reputation of the profession, to have people who've committed a serious financial crime on their register. Isn't that, am I right? So fitness to practice is not the only test of whether a sanction should be imposed. Am I right about that, or am I barking up the wrong tree?
Would the rules give me 1 moment?
Sorry, I don't want to raise a point that isn't really relevant, especially in view of what I've just said. But it's only I was tempted into it by your referring to this subparagraph 4, subsection 4.
I know that those who instruct me will have this fact at their fingertips as to where fitness to practice is referred to in the rules and the Act. But certainly if one goes back to, one doesn't need to do it physically.
Oh, I see. Is your point going to be that the concept of fitness to practice is a composite, doesn't only cover whether you actually do a good job as an osteopath? Well, that may be a complete answer.
Yes.
Okay.
That would be the ordinary position.
Yes.
It comprises all the reasons why
I see.
regulatory intervention may
Speaking for myself, I needn't hear any more about it. Thank you.
Can I just ask you, Mr. Rosen, where do we find the available sanctions to the committee? Because I can't find them at the moment.
It must be in the Act, not the rules.
I'm very sorry, I didn't hear my Lord's question.
Where does one find the sanctions available to a committee? I think it follows on in
Section 22 of the Act, page
Section
150.
Yes, I see.
And I've just done an electronic search which, rightly or wrongly, has confirmed me in the view that I don't think the rules or the Act use the phrase fitness to practice. I think there used to be fitness to practice in the previous version of the Medical Act, but I don't... Anyway, it doesn't matter.
I'm looking at section 22(3) on page 150.
Yes.
And if it's a conviction case, but the committee decides the criminal offence has no material relevance to the fitness of the osteopath concerned to practice, they may take no further action.
Yes.
So that feeds into 26, Rule 26.4.
Yes.
Whereas if it's a conduct case, you can't take no further action. You have at least to admonish the osteopath, and you get that from 22.4.
So my electronic search was a snare and delusion, because my lord has just identified one reference to fitness to practice.
Well,
Yes,
it's
so
fitness rather
Right,
than
section
fitness
20 is
to
headed professional conduct and fitness to practice. I'm just looking for it where it's a defined term.
Interpretation section is at 41.
I don't find it there. I mean, the concept is throughout section 20, but it's not actually. I mean, for example, it's in 2010. No, sorry, 2011. Oddly enough, it's not. Well, I think, may I suggest that probably, although, like my lords, one likes to feel firm ground beneath one's feet about all these key concepts, not actually sure this point is essential to what we have to decide today. So if you can get us to where fitness to practice is defined, do it later, but let's move on for the moment.
May I invite my lords to go to page 201 at the bottom, which is Rule 27, cases relating to conduct or incompetence. The lords will recall that those are two of the heads set out in section 20, so it rolls together those two. And again, we would submit that a careful reading of the rules suggests that what one ends up with the same three basic stages. Stage one is the determination of facts proved by the regulator, and there is the potential for various submissions of no case to answer, if I can use that abbreviated term. And perhaps one should look at the detail of it. Subsection 1, in cases of conduct or incompetence, the chairman shall ask the osteopath whether he admits any or all facts alleged, and in respect of any such facts so admitted, the committee shall record a finding that those facts have been proved. So again, admissions first. Admissions go straight to proof. 2, where all the facts are admitted, the osteopath or his representative may submit that in respect of any complaint where the facts have been admitted, those facts are insufficient to support a finding of unacceptable professional conduct or professional incompetence. So just pausing there, that's a submission of no case based on admitted facts alone, and bears out, I would submit, that had objection been taken to the limited significance that could be attached to what was said in the charge, there certainly was scope to make the submission at that point under the rules. Where it's made, the solicitor may answer, sub-rule 3. 4, the committee shall consider and determine whether to uphold the submission, so it's resolve any such issues on a submission. And then one moves on to the evidence that needs to be adduced and considered. That is evidence by the GOSC, with respect to facts that remain that have not been admitted. So that's subsection 5. If none or some only of the facts are admitted, or if the committee does not uphold any submission under Rule 27.4, the committee shall proceed as follows. A, the solicitors shall open. B, witnesses can be cross-examined. C, if on any allegation no evidence is adduced, the committee shall record and announce a finding that the osteopath is not guilty. So plainly that relates to, in effect, the offering of no evidence, where no evidence is tendered at all in support of a particular charge. And then we go on to 6, where the solicitor has closed his presentation of the case. This is the second opportunity to make a submission of no case, but it's based on 2 potential limbs. The osteopath or his representative may submit that in respect to the facts alleged but not admitted in the complaint, no sufficient evidence has been adduced upon which the committee could find the facts proved, and B, in respect to any allegation facts adduced or admitted are insufficient to support a finding of unacceptable professional conduct or professional incompetence.
So the whole of Rule 27 is stage 1 with various refinements.
Yes.
Yep, okay.
Well, so far, at the end of Rule 27, you've only got to the end of the prosecution case and any submission. You've not had a defence case.
Yes.
Yeah.
It goes to 29.
Both of them,
Yes,
are
my
the
lord.
whole
Right.
of 27 is concerned with stage 1, but so is 28. And indeed, so is 29 and 30 and 31. So you then go on, 28
there is, well, 29 is the end of the fact-finding for the allegations complained of. And then the next stage, 30, if it so determines that some of those facts have been proved,
yes,
it must next decide whether the facts amount to UPC.
yes.
I mean, there may be 3 stages, but they're not quite the same.
No, they're not.
Because of the whole nature of a conviction-based allegation means you've got to take it in a different way. So if you were, I'm not sure it's important for you to do so, but if you're attempting to suggest that the stages here are of exactly the same character, I don't think that's likely to be true, is it?
Well, they obviously have different features, and there isn't express provision here for the adducing of further evidence relating to unacceptable professional conduct or professional incompetence.
Well, that may be one of the points that's taken against you.
It is, although not in quite the same form that the judge determined, as I understand it, because it was Mr. Wray who called for further evidence by giving evidence at the UPC stage. So that was the further evidence that came in.
Yes, but I'm picking up my Lord's point that the stages are not the same as a conviction case, because in a conviction case, the allegation is you've been convicted. And the only issue on that is, have you been convicted? Is it you that's been convicted? And has the conviction been proved? And that's stage 1. And then you go on to, well, let's hear your mitigation, and let's hear whether it has any impact on your fitness to practice. And if it has no impact on your fitness to practice, then even though you've been convicted, so the allegation's been proved, the committee can agree to take no further action. And if it's not one of those cases, the mitigation and the circumstances can all feed into the appropriate sanction. This conduct is rather different because the allegation is you're guilty of UPC. And you first have to find out what the facts are, whether they're admitted, whether if they have been admitted they're capable of being UPC, if they're not admitted, whether they're proved, again, whether the prosecution case is capable of being UPC. If it's capable of it, then you hear the defence evidence. So all that is a fact-finding trial. But that doesn't lead to the allegation being proved, because once you've found the facts, you then have to go on and ask, do those facts actually make a finding of lead to a finding of UPC, which is a different stage, which has no equivalent in the conviction case. So I agree with my lord that I don't think the stages are really the same in the two types of case. And I think there is a question as to whether there's a further round of factual evidence between Rules 27 and 28, which are the factual evidence stages, and between Rule 29 and Rule 30. 29 is, have the facts been proved, and then 30, does that amount to UPC? And there's certainly no express Rule 29A saying at that stage you can adduce further facts. So I think there is a real difference between the structure of the two sets of rules.
Well, I don't, with respect, disagree with the analysis of how one breaks up the rules. But in fact, in basic terms, there is an establishment of the relevant factual matrix, stage 1, an evaluative stage, stage 2, and a sanction stage. So in that broad sense,
I understand
that the same stages apply. But the laws have the point that there is, between 29 and 30, no express provision for the adducing of further evidence at that stage. I know my lords will have considered what we've set out in our scopes of argument, and the fact of the matter is it is done. And in this instance, it was done by the registrant himself choosing to give evidence.
And there is, I think, a general power in the committee to adopt procedure.
There is. The judge referred to it in her judgment. It's contained in the statute. And there is a wealth of common law cases talking about the ability of a regulatory tribunal to do anything in the interest of natural justice that is not inconsistent with their rules.
So your point is it's quite difficult for the registrant to complain that he was allowed to give evidence, and then they took account of it.
Yes, and indeed I would go further. It is difficult for the registrant to complain about what came out in the course of him trying to avoid a finding of UPC by adducing further evidence.
Yes.
If you say it's not so bad, the committee is entitled to ask questions to ascertain whether it was so bad.
Or perhaps even worse.
Indeed.
Yes, I see. Thank you. That's very helpful.
I think the laws will see Rule 33 deals with the plea and mitigation stage, so that may be an aid to construction in relation to the earlier point that was raised by the Lord Justice Stuart-Smith. I mean, it must be the case, as a matter of common sense and natural justice, that a registrant gets the opportunity to put in their mitigation, regardless of what course is adopted in relation to evidence by the regulator. May I draw your attention to Rule 34, questions by the committee. So this is particularly to UPC or incompetence cases. At any stage during the proceedings before the committee, any member of the committee or the legal assessor may, with the chairman's permission, question those presenting evidence or any witness called.
So what?
One probably didn't need it, but
You're not suggesting that that's, as it were, carte blanche to reopen matters at any stage?
no, it's a matter of common sense that if you choose to give evidence, you can be questioned not only by the solicitor but by the committee itself.
The trouble is, by the time you get to mitigation, under the rules, the committee has made its determination, A, as to the relevant facts, and B, as to whether the facts amount to UPC, and they should have announced it. So before you get to mitigation, what's described as mitigation, the registrant knows, and it has been fixed, what facts have been found against him, and whether and to what extent they amount to UPC.
Yes.
So, speaking entirely for myself, I have some difficulty in the suggestion that the undoubted flexibility for the purposes of complying with rules of natural justice that the committee has is a ready response to what looks to me like a watershed moment.
Well, I respectfully agree with your lordship in this sense that if one reopened or opened afresh wholly new factual issues in the course of mitigation, there would be a legitimate argument as to whether that goes beyond what they are permitted. But in fact, and one shouldn't lose sight of this, as I understand it, it's common ground that the registrant in this case did not give evidence merely in relation to mitigation. He gave evidence in relation to UPC. One, in fact, finds that in, and I know what the judge said, in my respectful submission, the judge got it wrong. Perhaps I can take your lordships to the relevant part. It is the PCC decision in the core bundle, which is at page 86 in the core bundle.
You may at some stage need to show us the transcripts if there's any dispute as to what actually happened.
I will do. Yes, perhaps as to this point as well. Yes, I take my lord's point. But in the PCC decision itself, if my lords then go, I invited you to go to the beginning of the document, page 88 at the bottom, under the title Evidence. Paragraph 6, noted bundles and skeleton arguments before it. And then paragraph 7, this is the critical point, the committee also heard oral evidence from the registrant in relation to the question of UPC. And then it goes on, paragraph 7 and 8, to outline the evidence that he gave. But
the rest of 7, although that's how it's introduced, the rest of 7 is classic mitigation.
I don't respectfully disagree, but if one goes on to paragraph 8, one sees the meat in it, which is his evidence about further circumstances leading to the offence, I say offence, the determination in question. Whilst we're looking at it, may I respectfully draw the court's attention to the end of paragraph 11. This is the critical part that the learned friend attaches importance to. At the top of page 89, he acknowledged that there were about a dozen members of the public nearby who were customers of a wine bar. So that's where the bystanders' evidence emerged. It emerged in the course of his own evidence.
But this goes right back to the beginning, doesn't it? It indicates the critical importance of the complaint and of a regulated process by which the facts underlying the complaint are determined and a decision is made as to whether the facts that have been alleged from the outset or by amendment are proved, because that gives you something concrete upon which then to decide UPC. And by the time you get to mitigation, the question of UPC should have been decided. I can see under the rules that you could have the committee saying, hang on, I don't think we've got enough evidence yet. Let's go back. You can see how that could work under 27. But at the moment, subject to anything you may say, that's not what happened here. And I also acknowledge that mitigation can sometimes go horribly wrong.
Well, I respectfully agree that there is a demarcation between what can happen in relation to the mitigation exercise and what can happen in relation to the assessment of whether there is UPC. The reality of the matter is that often in disciplinary tribunals, when the registrant steps into the witness box, they give evidence about a number of different issues. Rather than going in twice, they deal with matters that go to impairment, or UPC in this case, not impairment, but impairment in other regulatory schemes, and they also can touch, as a matter of convenience, upon matters that go to mitigation. And sometimes it's a little difficult to draw the line between the two.
And am I right in thinking that by the time that the registrant in this case gave his evidence, which he did once,
Yes,
no finding of UPC had been made?
that is my belief.
So the rules set out a fairly clear structure which distinguishes between finding the facts, admitted or proved, making a finding of UPC, and then mitigation, which feeds into sanction.
Yes.
But in practice what happened is the facts alleged were fairly bald and admitted.
Yes.
There was then evidence from Mr. Wray which went to the question of whether those facts amount to UPC, but also went to mitigation,
Yes.
all rolled in together.
Yes.
Then there's a finding of UPC, and then there's a sanction. Is that how?
That is precisely how we would put it. And it is right, as the court has noted, that there is no express provision for the introduction of evidence at that stage, but it would be grossly unfair to most registrants to stop them from adducing evidence or giving evidence on their own behalf to provide context for matters that they
at that stage, because the allegation is in fairly bald terms and could cover a range of conduct from the most serious criminal offence to what Mr. Wray was putting forward here, which was it was a mistake, which he accepted, and he accepted that he'd done what was alleged, but the circumstances were very much at the other end of the spectrum.
And just building on that point, this case illustrates that drawing the dividing line between what you characterise as getting a balanced view of the circumstances of the offence and what you characterise as mitigation will often be very blurred.
Yes.
A classic, you can see nice straightforward cases where they committed some criminal offence and then they say, but things were going very badly at home, and I had a medical condition or whatever it was. That quite easy to divide the line, and you might even say, well, look, we'll hear you about that later if we find that what you did was unacceptable. But here, at what point do you stop saying the circumstances leading up to the offence aren't part of whether it's unacceptable conduct? It's a very blurred line. But I don't know who that helps, but it is the case. Isn't it?
I agree with my lord, but I've got a niggle going on which I can't quite get rid of. If you add in the feature of the bystanders, it could be said that you're effectively alleging an affray, which was not alleged against him. And it seems to me there is a point of real principle, which is whether the council can go beyond the facts alleged in the complaint when deciding whether or not UPC is proved. And it's, at the moment, it seems to me the structure is all geared to proving the facts in the complaint. and making a decision of on UPC on the basis of the facts in the complaint, which have been proved. And so I have a residual worry either on natural justice grounds or where I don't know where it's coming from, that bringing in the bystanders is changing the complaint without formally doing so.
Well, my lord, in my respectful submission, it goes directly to the potentially aggravating issues central to the offence itself of having an offensive weapon in a public place. If, for example, you were in an alleyway where unfrequented by anyone, it would be a good piece of mitigation to say, all right, it was a public place, but nobody saw it, nobody was even capable of being subjected.
But you could have charged it as being in a public place and liable to affect members of the public.
Yes.
In which case there could be absolutely no complaint and you'd have to prove it.
Yes.
And you'd get to the point where the facts are found and then you say, is this UPC?
Well, the simple remedy would be not to step into the witness box, at which point the committee would be bound by such facts as were apparent from the evidence
simple remedy
that was
is
placed before it.
Well, I don't want to be contentious, but the simple remedy is to follow the structure of the rules.
But it maybe one of the difficulties is that in an admission case, what you admit is what's charged, which may give very little detail.
Yes.
If it's a non-admission case, and you have, as it were, a full-scale prosecution, the prosecution will call all the witnesses, and they can be cross-examined, and so on, and the defence will call the evidence, and the committee will then have a full picture of the facts, just like a jury, and be able to decide what the facts were, all the facts. Were there bystanders? Were they affected? Was it dangerous? Etc. And on the basis of that full finding of facts, be able to decide whether it amounted to UPC or not. But when you have a case like this where you're charged with an allegation and the particulars given are fairly bland, had an offensive weapon without reasonable excuse, the committee really needs to have flesh put on those bones somehow in order to decide both whether it's UPC and how serious it is if it is.
Could I ask this? Suppose a case of misconduct which was not didn't fall within the parameters of a criminal offence. So the option is not available to the secretary simply to spell out the ingredients of the offence as they appear in the statute, which is what happened here. Is it normal practice just to say the offence is that you behaved offensively towards your colleague X on such and such an occasion? Or in such a case, would it be the practice to set out in the complaint a good deal more detail of what exactly you're alleged to have done? In other words, is this because this happened to be a criminal offence, which not all misconduct will be, that it has been so economically charged? Do you follow me?
Yes.
Maybe you don't know.
No, I think the fairest answer is yes to your lordship's question.
I've forgotten exactly how I framed the question. Do you mean it would, in an ordinary conduct case, it would be more fully spelled
I would
out?
put more in. Yes.
That's certainly, my experience is very out of date, but my experience, which is mainly in GMC or dentists at the bar, was that the complaint set out what the regulator set out to prove.
Yes.
And that was treated as being, and it might be amended, but that was treated as being the document which defined the parameters of the case. And if you were acting for the doctor, it was those were the allegations you tried to disprove or get out of. And if you were acting, as I typically would be, for the regulator, then that's what you're going for. And then you have to say to the regulator, I've proved A, B, C, D, E, and F. I may not have proved these three sub-allegations, but if you look at those, they're what were alleged, or they were part of what's alleged. They've been proved. That's amount to what's now called UPC. That's why I'm banging on about the centrality of the complaint.
Yes.
And one's looking at that case, therefore, obviously it'll change, but at a page or two. I mean, if there's lots and lots of allegations, it may be more than that.
Yeah.
But one's certainly looking more than a single phrase like we have here.
Yes.
Yes.
Yes, the Lords have our point, I know, that we say that is correct and proper on the facts of this case, because it was a weighty piece of evidence that was admissible, and it proved all the facts implicit in the...
Yes, but you see, even if this was a criminal offence, suppose someone pleaded guilty,
Yes.
and there was and the judge wanted to know more about the circumstances before proceeding to sentence.
Yes.
And there was a dispute, there would have to be a Newton hearing. And for the purpose of the Newton hearing, there would have to be, I've now forgotten, so long since I've done crime, I forget whether the Crown actually has to produce on a document what it's intending to prove, but certainly it will be, by one route or another, it will be made clear what are the circumstances which the Crown says are relevant to sentencing, but do not appear simply from the admission. And everyone will know what the dispute is about. And
Yes.
facts like this, it might well be that he pleads guilty, but on the express basis that although it was technically in public, there was no one within 1,000,000 miles. And the prosecutor may say, no, I don't accept that. There were women and children looking out of the windows. And then that would be the issue on which there would have to be evidence. Now, I'm not quite sure where this analogy goes, but as a matter of justice, you've got to know from the start all the facts that are relevant to sentencing,
Well,
from the prosecutor's point of view.
I say this tentatively, but it may be that the Lords are under a misapprehension as to the totality of the evidence that went in following the admission to the charges. What went in, so I can take the Lords to it, is a documentary bundle tendered by the GOSC which contained documents relating to the underlying facts.
Right, we'll certainly look at that, but that's not quite the same thing, is it? Because you've still got to have a statement of what are the... I would have thought you've got to have a statement by the prosecutor. These are the elements
Yes.
which make this unacceptable professional conduct.
Yes. Maybe I'll have to go back to the chapter and verse. but my-
Well, anyway, sorry, you were going to show us where we find the bundle.
I was. If you go where we were in the PCC ruling, page 88, paragraph 6, the committee was provided, this is under the title evidence, with a bundle of documents comprising the council's hearing bundle and a second bundle comprising the registrant's bundle. And then in your supplementary bundle, we have included certainly the respondent's hearing bundle at the GOSC. That's at pages 38 to 104. I don't think we've included the GOSC bundle. It may be that we should identify that.
It's not their fault.
I just thought we'd like to see it, wouldn't we? Complete this. We'd like to see the GOSC.
Yes.
Yes, I think we ought, whether there's any point to be made about it, but I think for completeness, we ought to have both of the bundles referred to in that paragraph.
Yes.
I agree with my lord, and not least because we're going to see the complaint itself, but we have got the skeleton argument on behalf of the council before the PCC, which sets out, for example, the allegation on page, I think, 167. It says on 166 the allegation.
Sorry,
is it page 166 of the supplementary bundle? Which in my
no, 166 in mine is the statute.
Yes.
This is the point we made earlier about.
Well, could it be 107 on the side of the
107,
page?
the numbers are on the side.
It's after the sentencing guidelines and stuff. So it's
The
after.
numbers are on the side for this document. It's 107.
It is indeed.
107 is a photograph in mine.
On the right-hand side.
Oh, the sideways up
Side
one.
numbers.
Side numbers on the side.
Yeah.
In the middle of the right-hand side.
Yes, I have it now. Yes, thank you.
Page 111 is the respondent's skeleton argument. Again on the side. And there's a further skeleton argument at page 114, specifically on the question of unacceptable conduct. Which the court may note, actually, it refers to the case of J.R. Retnam.
Let me just get the dates of these skeleton arguments. The skeleton argument of the GOSC is dated the 21st of July, which was the date of the. So, what was the date of the hearing?
Mine's dated the 22nd.
30th.
Yes, so it was a week, but it was 8 days before the hearing.
It was a skeleton opening, as we understood it.
Yes.
And then the one at 111 is also 8 days before the hearing.
Yes.
And the one at 114 is the date of the hearing. We could probably, if we checked it against the transcript, see the moment at which it was submitted. But it says the registrant has admitted to factual allegations 1 and 2, but not to unacceptable professional conduct. That suggests he'd already done so. I'm not quite clear when. Sorry, we're getting perhaps off the point, but you were drawing your attention to these skeletons.
Well, my Lord, whilst we're looking at page 114, may I draw the court's attention to paragraph 2? I was going to invite the court to go to it in due course. It is the... There are more, but it's a convenient record of the fact that the respondent recognised that he could not go behind the decision to conditionally discharge him.
Where are you?
My Lord, it's paragraph 2. If you go to the second sentence, R recognises that his attempt to appeal the decision of the court was refused, so he had to accept allegation 1. Therefore, for that reason, recognising that he cannot therefore go behind the decision to conditionally discharge R. There is a case called J. Retnam, where the tribunal went behind the decision of the court, so there is a precedent, but R believes he has to accept that following his then lawyer's advice, he pleaded guilty. So
Yes, but what about footnote 2 on page 107? Which seems to be an acceptance by the council, at least at that stage, that a conditional discharge does not constitute a conviction for the purposes of section 22 of the Act. So we're right into the area of what seems to me to be fuzziness.
Well, that's absolutely right. That's why they went down the conduct route, which is the conventional. I beg your lordship's pardon.
Yeah, you go first.
Which is the conventional approach, where you're dealing with a conditional discharge conviction. You can't use the conviction route because the sentencing provision bites with respect to a suggestion that it was a conviction. So you go down the conduct route.
So the effect of that is, on one view, that instead of there being a conviction which itself can provide the foundation for it. The fact that he pleaded guilty is only a matter of evidence. It's not a matter of fact of itself. It's a matter of evidence that he has, on a previous occasion, accepted the facts that were alleged against him. And that's the difference.
That is the difference.
On which view paragraph 2 or allegation 2 or particulars 2 is irrelevant because it's evidence, not facts.
Well, it becomes evidence when he accepts it.
Yes, but the allegations or particulars are meant to be what you are alleging,
Yes.
not the evidence in support of it.
What you are alleging is culpable conduct, evidenced by a guilty plea to a criminal determination.
Well,
I'll use
but
the
then I think you're agreeing what my lord and I are putting to you, aren't you? I mean, particular 2 is redundant, isn't it? Do tell me if not. I think it's quite an important point in the case. But
Yes. Would my lord give me a moment? I'm not sure that I would agree with respect, because the guilty plea, yes, it is evidence, but it's evidence of a confession.
It's evidence. He's not going to be struck off for pleading guilty.
No.
The fact that he pleaded guilty may, in appropriate circumstances, be a very potent source of evidence.
Yes.
That the facts that you're alleging in particulars 1 are correct.
Yes.
That's, I think, how at the moment and that's consistent with what Mr. Justice Edis said in whatever the case is called, which we've been referred to, where he says the fact of a guilty plea is potent evidence.
Yes.
Lord Justice Edis.
I recognise the force of what your lordship says. I was going to say something to this effect earlier in relation to our discussion about particularisation. There has been a debate going on in the regulatory sector for the last decade or so as to the extent to which it is helpful to put narrative in your particulars when you are making an allegation. And practices have differed over the years, so that, for example, in the General Medical Council, the style nowadays is not to include narrative, but to boil down your allegations to what you're actually saying in very concise terms. The registrant did wrong, and no doubt the court would regard that as a desirable development in the field of regulatory law.
Well, what really matters is
Yes.
that there should be absolutely no doubt whatsoever about what is alleged to constitute UPC.
Yes. Well, in my respectful submission, paragraph 2 doesn't detract from what was the essence of the allegation, which is...
I accept that.
you may be right. It's not. That's why I say it's not necessarily fatal to your case to include a redundant particular. But it's. I think for clear thinking, my lord and I at least are putting to you, and I think you're not really challenging that this was, strictly speaking, redundant because it's evidence.
Arguably, we could have done without it. I say we. The GOSC could have simply alleged the commission of the offence and then put in such evidence as it had relating to the fact that it was a guilty plea. Whether the fact that it was a guilty plea makes a difference may or may not fall for determination by this court, but it's certainly a useful exercise to invite the registrant to accept or not accept.
With the complaint goes the material upon which the council's going to rely.
Yes.
That's the on any view, it can be put in there. Or at least I wouldn't object to it being put.
But speaking for myself, I think I would be in the succinctness camp about how you express, because there's absolute clarity then about what is the essence of the unacceptable conduct. But that is likely to lead to problems of exactly the kind that may have occurred in this case, what I might call Newton hearing type problems, unless the charge, which is succinct, is accompanied by a clear statement, either in the form of evidence or from some other document, of such surrounding circumstances as may be relevant, both to whether the conduct is in fact unacceptable and to sanction if it is admitted or proved. And I think that is in a sense where we jumped off, because you were saying, well, this wasn't all they had the bundle that we put in front of them.
Yes.
And you were about to show us that, and then it became clear we didn't actually have the bundle in front of them. But we can still see we can get the flavour of it, perhaps, from Mr. Collins' skeleton argument, which extracts from that material the key points at page 108.
Yes. But I wonder if I might just revisit paragraph 2. On one basis, of course, one doesn't need it, in the sense that the culpable conduct is adequately pleaded in paragraph 1. But on the basis of paragraph 1, one wouldn't know that he was ever charged or came before a criminal court.
No, but that's not relevant, is it? Well, it might be relevant as evidence, but it's not relevant to the conduct. The conduct is the same whether you were charged or not. I mean, can I just, before you answer, take another situation. This happens to be one where it's technically not a conviction because of section 14, subject to any submissions you may be going to make. But you could have other circumstances where something which is plainly a criminal offence, was never even charged. Might, for example, be a summary offence for which the time limit had expired. Now, the council could do one of two things in that situation. It could simply allege the conduct and say doing this, driving at 80 miles an hour in a pedestrian zone or something, was a conduct, unprofessional conduct. Or it could choose to say it constituted the offence of whatever offence it was. You could do either. In this case, you chose to do the latter. That's fine. But that's a case where there would never be any question of him having been charged, because it wouldn't be material. And it's not really material here that he was charged. It's only material, evidently, that he admitted to doing it.
The alternative way of looking at it, which I would invite the court to do, is that if one looks at the line of cases, including Estefan, the fact that someone was convicted or pleaded guilty is a matter which directly goes to issues of public confidence. Because how can a regulator do nothing when someone has been publicly convicted? And that is just...
But then you go under the conviction route.
Well, you can't, because of the effect of the sentence.
Yeah, well, there you are. That's because the Parliament has said you can't. So then you've got to go one of the two routes I suggested. That may be a very good reason why you want to say not only you did this thing, but you did this thing and it was an offence, even though you haven't been charged with it.
But I asked rhetorically, why shouldn't you also say not only did you do it and it was an offence, but you were in due course subject to criminal proceedings and you were subject to a criminal determination. Now, you are of course entitled to the protection of the sentencing provision for the purposes for which it's designed. But you're not entitled to say, I wasn't publicly convicted. wasn't publicly the subject matter of a criminal determination.
That's the wrong way of putting it round.
It is.
The council is or is not permitted to say, as a particular of misconduct, that you were convicted
It isn't,
because of Section 14.
of course.
Subject only to your arguments, which at the moment I'm not entirely sure I understand, about how somehow it comes back in. But and it's just a parliamentary policy decision.
Well, that was certainly the way the learned judge interpreted the matter, but I would respectfully submit that it is in the face of well-established authority, to the effect that this is a semantic provision that's got nothing to do with deploying in disciplinary proceedings the fact that somebody not only did the act, but that they pleaded guilty to it in a criminal event, in a criminal court.
Can I pause here? I'm concerned, and this inevitably happens because the court starts to ask questions, but that your submissions are being brought out somewhat piecemeal. You started very systematically, taking us in some length through the rules, which was helpful. But I think we want to get back on track.
Yes.
And enable you to make your submissions. Hopefully, if we don't ask you too many questions, I don't promise not to ask you any, are you likely to be able to make your submissions, having laid the ground so thoroughly, by lunchtime? If you're not, you won't have much time after lunch.
Yes, I will certainly do my best. It may mean that, subject to your lordship's view, we will go lightly in looking at the detail of the case law.
Wherever you want to take us,
yes,
within reason.
May I begin by addressing ground one, and we read out precisely what it says, but in broad terms, what we say is that the High Court wrongly construed Section 14, the sentencing provision, as requiring the regulator to re-litigate the factual basis of the guilty plea in criminal proceedings.
I'm so sorry, where are we reading this from?
Lord, it is my skeleton argument.
Yes, I see. Just slightly confused. The grounds, which you've actually got as 11,
yes,
start with the grounds in the High Court. And oh no, sorry, I've got that wrong. No, I'm misreading it. So what you're reading out from your skeleton is exactly the same as we find at para 11, is it?
It is, yes.
Well, it isn't quite. Sorry to be picky straight away, having invited you to, but we need to proceed by reference to pleading grounds unless we're told this is a useful paraphrase, which it may well be. But
yes, well, the pleaded grounds were the ones that I sought to read out at the outset. So let me stick to that wording and reorientate myself and the court to the actual wording. The suggestion is that the High Court wrongly went behind the adjudication of a criminal court and dealt with a registrant in a manner that was inconsistent with his guilty plea before a criminal court, and in so doing wrongly interpreted Section 14 of the Criminal Court Sentencing Act 2000 to the effect that it requires a statutory regulator to re-litigate the factual basis of a guilty plea before a criminal court. And I've attempted to distill that.
yes, no, that's fine. Okay, so you're going to show us where the judge did that.
The Lord, yes. I'm going to go to the judgment itself in a moment, but may I draw the court's attention to our attempt to summarise the relevant points.
Yes.
At paragraphs 19 and (19 to 20), I think, is the essence of it.
Of your first skeleton or second?
This is the first skeleton, and the point that we seek to make here, to summarise it, is that the effect of the judge's finding was that it was wrong to deploy the conviction at all. And to pick out some highlights, without going to all of them, could I invite you to go to paragraph 22 in the judge's ruling, which you'll find in the core bundle at page 37, bottom centre. So paragraph 22, it deals with the form of the pleading, and it goes on to say the implicit allegation was that all of this, or at any rate the underlying conduct, amounted to UPC. And then that's the context for the key passage at 23. Mr. Foe, I go down 3 lines. Mr. Foe says on behalf of the GOSC that the effect of section 14 is only to wipe away the status of conviction as such. So, for example, if a prospective employer asks about convictions, nothing need be said, but not to wipe away the historical facts of the underlying criminal process. I was shown no authority for that proposition, and it is on the face of it surprising. The plain words of section 14 entitle someone to be treated, not least in an employment or professional context, as not convicted. If that could be got around by indirect allusion to conviction, including by reference to the spent conditional discharge itself, it would be set at naught. The allegation in this case clearly identifies Mr. Wray as convicted. On the face of it, that disregards his legal protections. So the essential point, to use my own terminology, is the judge thought it unfair to get through the back door what you were not entitled to get through the front door. And one can well understand, in the absence of authority, why one might approach the question in that way. And it is right that none of the authorities that we have subsequently cited were cited to the judge at the time. We have explained the context to that, which is that it was not in fact a point that we understood, or reasonably understood, was taken prior to stepping into the High Court. It was really an issue that developed in the course of the hearing itself. And I don't detect in my reading of any of the submissions that Miss O'Rourke made at the time that she had flagged up the suggestion that you were not entitled to deploy the conviction at all. Her case was, it didn't amount to much, and there were other things that went wrong.
Certainly on the basis of her skeleton, the thrust was, as it seems to me, that the committee took into account things they shouldn't have taken into account, like the presence of strangers.
Yes. And then, again, sticking to just a few references, I'll give another 2. Paragraph 36 in the judgment. After referring to the case of Samuel, the learned judge says, 4 lines down, all there was the plea and conviction, and the conviction had been wiped away. And then, towards the end of the judgment, paragraph 48. Perhaps.
I'm very sorry, I didn't. The last paragraph you referred to.
48.
Thank you.
Lord,
And the one before that.
the last one was
36.
36.
Thank you.
48 is part of the conclusions in the PCC decision. 48, in bringing this as a UPC case, the PCC must have accepted that it was not open to them to bring a conviction case because of the 2000 Act and the public policy considerations underlying it. Yet without using the word conviction, the allegation made was in terms of charge, plea and sentence, necessarily implying conviction. That is in substance an allegation of conviction which is, in my view, contrary to the letter and spirit of the 2000 Act and unfair to Mr. Wray. So as I've said, one can well understand why the judge took that view in the absence of authority, but as it happens, it was contrary to well-established authority. And the court will no doubt tell me if it's unnecessary to do that, but I should like to invite the court to go to the pharmaceutical case, which is in the authorities bundle at page 188. The 1980 decision of the Divisional Court, consisting of Lord Lane, Chief Justice, and Mr. Justice Webster. At page 188, one can read from the head note that it concerned the section 20 of the Offences Against the Person Act, allegation of wounding.
That's probably fair. If you want to make us read the whole head note, let us read it to ourselves. Or...
I wasn't.
Oh, right. No, okay.
to,
I'll do it your own way. That's fine.
I was going to draw the court's attention to one particular matter of importance. Letter G, following their convictions, complaints of misconduct were made by the Society to its disciplinary tribunal, the statutory committee, that the first respondents were guilty of such misconduct as to render them unfit to be on the register of pharmaceutical chemists. So it is a precise analogue because of the effect of the equivalent sentencing provision. They went down the misconduct route. If I use the internal pagination, now that we're there, that may be more helpful. Could I invite the court to go to page 890, top left? At letter B, the court will see that as with the GOSC, there are two routes, and they went down the misconduct route. And as a matter of practice, the Society deals with cases either as conviction cases or misconduct cases, the latter including cases where a probation order or an order of absolute discharge or an order of conditional discharge is made. This instant case, as the letter which I read indicates, was expressly alleged as a misconduct case. So it's been standard practice to do this since at least 1980, at least for the pharmacists. And the court might note that the relevant provisions giving the bifurcation between conviction cases and conduct cases is set out at letters E. I think Miss O'Rourke makes the point that there is a duty to make inquiry with respect to both routes. And indeed, that is borne out by letter G.
Up to you entirely, but bearing in mind what I said about timing,
Yes.
do we really need anything more than appears in the first holding in the head note at 887, which we can then see if we want to at 893, or indeed 891.
But the reason I did think it potentially worth going to this case is that it summarises the previous relevant case law.
Okay.
But it may be what I can do is just point out the relevant parts to the court to read at its leisure if it feels so inclined.
Well, only you know how much more you have to get through, but I'd have thought that might be a sensible course.
Yes. Well, may I invite the court to have regard to the helpful summaries of Harris at page 194. The relevance of this summary is that it shows that the court had regard to other cases in which, where there is a guilty plea, it was regarded by other courts, and implicitly by this court too, as acceptable and proper practice to lead evidence that there was a guilty plea in the criminal court.
You said by this court too. I think this was a decision of the divisional court, not of this court.
Sorry, that was an imprecise form of wording, I'm sure. What I meant was the court in question who made the decision.
I see. Yes, sorry.
So in Harris, the essential point is all of these cases concern people making pleading guilty in the criminal court. And if you look at the bottom of page 194, Humphreys J giving the judgment of the court says at the bottom of that page in the cited paragraph, no possible objection in our view could have been taken to the procedure adopted in this case if the detective constable whose deposition I've read had been present at the trial and had given evidence to the following effect. I was present at the court on the day named when the accused was there. I heard him confess to the charge. And the court will note, if one goes back a page, there's also a reference to the Privy Council case of Simpson. If the court looks at the bottom of page 891, using the internal pagination, the same point arises. There was evidence by deposition of the guilty plea.
Yes.
Could I invite the court please to go to page 156?
I'm sorry, I'm having a bit of difficulty hearing. Could you repeat that?
Beg your pardon. Page 156,
Okay.
bottom right.
Estefan. Yep.
Estefan, and again we're dealing with a guilty plea, but as the Lord Justice Stuart-Smith pointed out, the importance of this is at page 40, paragraph 43, which is at 167 at the bottom, right. Mr. Justice Warby, as he then was, described the taking of the sentencing provision point, if I can summarise it in that way, as being clearly without any merit. He said, it is a purely semantic point based upon the wording of the criminal statute, which has no material bearing on the issue which the panel had to decide. The substance of the matter is that a criminal court was satisfied, so that it was sure that Mr. Estefan had driven whilst disqualified, a matter which, as it happens, he admitted. And goes on to say the issue before the panel in 2013 was whether he, knowing that, had failed dishonestly or otherwise to disclose that fact to the HCPC. So, pausing there, a slight qualification, the misconduct allegation rode on the back of the determination. The panel found that he did fail, but did not find that this failure was dishonest. The characterisation to be given to the finding of guilt under the Act of 2000 is wholly immaterial.
Yeah, but it's a very different context. It's a completely
Context
different
is
issue.
different, yes.
Yeah.
But I would respectfully submit that it's in line with the leading cases that we invite the court to have regard to. And we say, in our skeleton argument, that it has a bearing on the question of whether entering a plea makes a difference, whether a different approach prevails where someone does not plead guilty to the offence. And we say you don't need to determine that question, but if you consider it appropriate to do so, we respectfully submit that it should be answered by coming to the conclusion that it should make no difference. There is added weight to the plea, perhaps, but all the other public policy reasons for concluding that conditional discharge convictions can be deployed in disciplinary proceedings apply. We deal with that at our paragraph 30. We raise the question and we seek to answer it at paragraph 33. The second sub-point that we make under ground 1 is that which we set out at paragraph 30 onwards in our skeleton argument. And we say this was a connected point, but the judge erred in concluding that the sentencing provision meant that it was open to the respondent in the disciplinary proceedings to renounce and contradict the criminal conviction. And I think the learned friend's point is, well, he had no need to renounce it, but I don't think that the learned friend takes issue with the fact that the learned judge found that he had renounced it and found that that was unfair and that she was wrong to do so as a matter of fact. On the facts, he had not, when it came down to it, renounced the conviction or what was implicit in it.
That's one of the oddities of the present case.
Yes.
That not only did he plead guilty when, on his account, he shouldn't have done, but he then admitted the facts. including the whole of count 1. Never mind particulars 2.
Yes. The judge was right that in his statement, if one looks at his written statement, which is in your bundle, he did say that he later found out he was wrong to do it. But he expressly resiled from that in the course of the proceedings before the committee.
Show us where he did so.
Yes. One needs to go back to the supplementary bundle. Page 111 at the side.
Para 8 and 9.
Indeed. So he said in terms, in the skeleton argument, he now accepts that he cannot go behind the decision and that pleading.
So this is the skeleton argument that is put in advance of the hearing, a week before the hearing.
Yes.
What, the date of the witness statement is earlier.
Yes.
Is this alluded to at all in the transcript?
It is.
Can you show us the passage?
Certainly. Whilst we're in this part, may I remind the court of the passage that we looked at page 114 on the side, paragraph 2.
Yes.
So that's in the later in-hearing skeleton argument, and it says effectively the same thing. In the hearing itself, I don't think we need to look at it, but the statement in which he makes the reservation is in a table which is appears at page 49 at the side. I don't invite you to look at that, but that was what the judge had in mind. But in fact, if you look at page 13 at the side,
1-4.
1-3, the matter was expressly dealt with when he was cross-examined, when he came to give evidence, letters D to G. Mr. Collins, you do not admit allegation 1 in the table on that page, so that's a reference to the page I mentioned a moment ago. Mr. Grant, sorry to interrupt, Mr. Collins is probably right in addressing it. I already said to you that we have withdrawn that, we now admit it. I should have put that question to him. I thank Mr. Collins for making that point, if that is the point. He has withdrawn that denial. Mr. Collins, just to end this line of questioning, and it was effectively just clarifying that position. Since the 21st of July and the present date, you have reflected on that position and have changed your approach. Answer yes, on advice of Paul, I admit it.
That seems fairly clear. And I mean, it's discussion of whether you can or cannot go behind a guilty plea is neither here nor there, is it?
If the court accepts that the judge got it wrong in concluding that he tried and was not permitted to renounce his guilty plea, then that is right.
Because in your supplemental skeleton, you've given us a wealth of authority on the circumstances in which you can do that. Do we need to get into any of that material if we accept what appears on the face of the transcript to be the case, that on advice he did not adopt that position?
The court would not need to do so for the purposes of determining this case.
Well, I'm very reluctant, speaking for myself, to decide things we don't need to decide.
Yes. But it will mean, in my respectful submission, that, with the greatest respect to my learned friend's position, that he did not need to renounce it, that is no answer to our point that the judge made her decision based on a fundamental misunderstanding as to the relevant facts.
The judge seems to have thought that he was ambiguous in his plea and that he really wanted to maintain the position that he wasn't guilty. But is that not right?
I think she said in terms that he had, which Lord should give me a moment, because I think it may be helpful if I actually take you to what the judge said. The references, the key references, I think, are at paragraphs 31, 47 and 50 of the judgment. We give, I think, a more comprehensive list at paragraph 20 in our skeleton argument.
So which, just give me those paragraphs again.
Lord, it's paragraph 31, 31, 47 and 50, 50.
31, 47 and 50.
Yes. So, 31, she says in terms, Mr. Wray expressly invited the PCC to go behind his plea.
Well, in his witness statement he did.
Yes, but as a summary of the entirety of what took place in the hearing, it is materially inaccurate. No doubt the judge was not at fault in forming that view, but it is, as a matter of fact, materially inaccurate. 47.
Did the judge have the transcript?
I believe so, yes. Yes, I can check that, but my recollection is that she did. It's part of the High Court bundle.
And the skeletons.
Yes.
But if you look at 28,
Yes.
she speculates. Perhaps if asked, he would have said something like, I accept I did plead guilty and that I did that, but I should never have pleaded guilty because I never intended to hurt anyone and I took the was a cast of therapy and defend myself. That's what his witness statement said.
Yes.
It seems that's what the PCC thought he'd admitted. If it had been clear to him that the factual allegations put to him included the facts of intent to injure and failure of written excuse, it's inconceivable that he would have accepted them. But what you've shown us on the transcript is that he, on advice, he did accept
Yes.
them.
But it's difficult, isn't it? Because on the following page, we've got a passage which happened in private. So, and for my part, I don't think we know what was said there. But then what he is saying is, I'm a caring person, I'm never aggressive, and so on and so forth. So that
It would have been a health issue, undoubtedly. I think Mr. Grant, who appeared before him, may be in court and may be able to assist, but that would be the ordinary reason for going into private.
and in re-examination by Mr. Grant, top of page 16 on the side. I just wanted to make absolutely sure about that. There was a reference in Mr. Collins' cross-examination to acting in an aggressive and violent manner. Were you charged, or have you ever been charged with acting in an aggressive or violent manner? No. So, speaking entirely for myself, one can see in retrospect it's unfortunate that he simply admitted. One can see where the judge got her idea from, but it's extremely difficult to pin down, except to say that on two separate occasions, once before the magistrates and once before the PCC, he did, in words of one syllable, admit the charge.
Can we just be quite clear what the ingredients of the charge were? They were carrying a or it don't matter, an offensive weapon, and the definition of an offensive weapon includes a weapon that you have with you with intent to injure. And it is, am I right in saying it is accepted law that an intent to injure in self-defence is still, on that part of the charge, still an intent to injure?
Yes.
Where self-defence comes in is reasonable excuse.
Yes.
And am I right in saying on the case law, if the jury accepts that your only intent was to use it in self-defence, that may be a reasonable excuse.
Yes.
Maybe always is, but certainly may be a reasonable excuse. So the bit of his plea that was a problem for him was accepting he had no reasonable excuse, because that precluded him from saying, I was only ever going to use it if necessary in self-defence. Have I got, is that the correct analysis?
That is, it was tantamount to accepting that there was an intent to injure, because that is the only way in which you can be caught.
Could be a contingent content. A contingent intent is sufficient for the
Yes.
commission of
My mistake, it's not a defence in front of a jury to say, well, I was carrying this bat, I was only going to use it if I was attacked. I mean, that's not,
No.
that's still what my Lord refers to as a conditional intent.
Yes.
But
Well, there
it's
are
short of that. Is this the ambiguity which obviously worried the judge? Clearly, in his own mind, Mr. Wray was saying, "I was never going to act aggressively. I was never going to attack anyone first." But it was open to him to continue to say that, and it wasn't really an issue. And he did say that in re-examination, and that was accepted.
Yes, I mean, it may be said that he advanced two positions that were not
correct.
readily reconcilable, and that
But they're not reconcilable.
the committee had to do the best it could with an express non-resigning from the conviction, I call it that, and the other comments that were made.
It is rather unsatisfactory. Of course, it is very express and very clear, and we've shown us the passages. Well, then, what was his intent? Well, you say, well, logically, it must have been because he accepted that he had no reasonable excuse, that in some circumstances, at least, he might use it otherwise than in self-defence. I would quite like to know what those circumstances were, or...
That's completely inconsistent with his witness statement, which was before the committee.
Yes, but then he backed down from it in the course of cross-examination.
Well, he backed down from not admitting all the facts in particulars 1, which is different, or arguably different.
Well, the court may wish to look at the table that was being referred to.
Well, I am just looking at it, yes.
That in mind.
But the other thing that's worth looking at is the way that the committee treated it, because they really accepted it. In the passage that the judge cited,
yes,
they really appear to me to have accepted that he was not going to use it aggressively.
Sorry, just before we go to that, which is more important, but I just don't want to lose this. Actually, if you look at the table, which I've been looking at page 100 in the supplementary bundle, it's something's gone wrong with the layout. You can't actually read it consecutively. Is the full text somewhere else? It reads, this is page 100, it's page 41, looking at the numbering on the side. Is this the table we're talking about?
Would your lordship know that?
Sorry.
Yes, it is.
So it reads, not admitted insofar as I will set out later why I subjectively...
No, that's a different column. If you look at the previous page, the middle column is response, and the right-hand column is comments.
Yes. It's page 41 on the side, the middle top box.
So not admitted insofar as the facts are concerned, but I was advised to plead guilty, so I did.
Oh, I'm sorry, I was reading it wrongly. But the other column is also relevant, I see, but then you picked it up earlier. Yes, so sorry. That was just stupid of me.
But
Can we get back to the more important point that my lord made?
Can we go back to paragraph 32 of the PCC's decision, which is set out in paragraph 20 of the judge's judgment on page 36, at the top? The committee reminded itself that there was no evidence before the Magistrates Court, nor was there any evidence before it today that would suggest the registrant behaved in an overtly aggressive manner when he stepped out his vehicle over and above his decision to equip himself with the softball bat. It accepted that the registrant made no attempt to move towards T or any of his companions, and that his intention in picking up the bat was as a deterrent or for self-defence. There's also authority which is mentioned in the citation from Archbold that you've given us, which is that the deterrence is not holding an offensive weapon unless it goes over into the prospect of causing injury.
Yes.
I think I've got that slightly wrong, but it's paragraph 183 or 178 or whatever it is. So, I mean, this is the section of the judgment, which or the citation, which I've got 3 stars against, because it does seem to me to be irreconcilable with his admission of paragraph 1. Or you've got to be very clever to see how it isn't.
Well, what the committee in the particular circumstances was entitled to do was to take the facts implicit in the criminal conviction, and given that the registrant had expressly disavowed renouncing those facts, to come to the conclusion that that was the one bit of solid ground that they could base their decision on. They recorded what the registrant said in evidence, and the inference is that he nonetheless admitted to a criminal offence, which necessarily involves intent to injure.
But they've accepted. They've accepted. I suppose the only conceivable answer is that they've accepted that he only took it for deterrent or self-defence, but have not accepted that taking it for self-defence in the circumstances of this case, where his car was being attacked by a group of 10 men or 8 men, constitutes a reasonable excuse for picking up the bat in self-defence.
Yes.
Whoa. Well, they don't say that.
They don't, but they were right in my submission to take the view that the bedrock constituted by the criminal offence necessarily involving intent to injure was firmly established.
Well, speaking entirely for myself, if I was sitting in a different jurisdiction, crimdiv, and I had what looked on the face of it like an unequivocal plea, but complete acceptance of no aggression, only taking up as a possible deterrence or thing, the conviction would look a bit wobbly, to put it at its lowest, wouldn't it? Well, that's my suggestion to you. Which you can disagree with if you wish.
Well, I would be repeating what I have already said. And our submission is that the PCC did the best it could in those circumstances in traversing both what the conviction had said and what the registrant said. And as my lord indicates, there is a route that one could theoretically go through, but it wasn't necessary for the committee, given the unequivocal resigning from the previous renunciation, to do that. It was entitled to regard, as I said, the conviction as being a simple, readily understandable piece of evidence which told its own story, and whilst it was right to have regard to such mitigation as the registrant wished to put before them, and indeed they did, he could not escape from the conviction, and should be sanctioned on the basis of it.
Now, I see the time. How much longer do you think you're likely to be? It's perfectly acceptable for the appellant to take longer than the respondent, because you've got to show us the key materials, but you can't impinge into the afternoon by much.
I will endeavour with a fair wind to complete the remainder of my submissions in a fairly skeletal form within half an hour or so, if the court will give me that indulgence.
Well, I think half an hour is the absolute limit. I think you should aim to get them done in 20 minutes, but let's see how we go. We'll sit again at 2.